6th, Monday, and this is the complaint committee. You should, on your iPads, number 5 is where you'll find the legal report.
Jarrell, were there any that you wanted to bring to our attention first?
No, Ms. Kingsley, I don't have anything to bring to your attention. I am going to turn it over, though, to Pamela Spicer and Allison Renfro. They may have some cases that they would like to discuss with you all. Thank you.
Good morning, everyone. I have cases 1 through 10 this morning.
Have any questions about 1 through 10?
Okay, thank you.
I had questions about 5 and 6. Wanted to know what was the service?
What was the what? I didn't hear you.
What was the service that they were performing?
Let me look at the file and let you know specifically. The notice of violation refers to practicing cosmetology with an expired license, but specifically practicing without a valid license for cosmetology manicuring. It does not specify which specific type of cosmetology service.
It's the same for 6 and 7. Will that be the same thing, basically?
7 is not related. 6 is related to number 5. And again, it does not specifically say what types of services. The inspector noted that there were services being provided without a valid license.
When does the joint license roll out, the dual shop? It's soon, isn't it?
We're expecting those rules to go into effect sometime in July, hopefully if all goes as planned.
And I'm assuming there will be a notification to our constituents on what that is and how they can apply for it.
I think that's something I'd have to discuss further. If it was going to be a special notice, of course they would be notified when the new rules went into effect, certainly.
I just get the impression, and maybe I'm right or wrong, but a lot of this has to do with a licensed barber working in a cosmetology shop, a licensed cosmetologist working in a licensed barber shop, and not understanding the overlap or the differences.
Correct.
Okay.
I may not have said that accurately, but yes, that's correct. Specifically for number 6, that is the issue.
This person had a barber license, but they were working in a shop with a cosmetology license, not a barber's license.
Correct.
Okay. Thank you. My next question was for case 16, and I know that, Allison, that moves on to your group, right? Did y'all have any more questions, 1 through 10?
No.
You want to talk about 16?
Absolutely. Quite a mess. This is a shop that has a shop license, but has on 3 occasions now been observed to be permitting unlicensed individuals provide hair braiding. So in 2015, the board authorized a civil penalty of $4,000, which the shop did not accept, and the following August, the shop was observed to be permitting 4 more individuals to practice without a license. There was no manager present, and the shop license had been suspended at that time. So then that was an additional $5,100, and I joined the department in June. So these were coming together before I was assigned to these cases. But once I was reviewing what open cases I had, I saw that and asked Roxana the best approach, and she said that usually it's like a 3 strikes kind of situation. So once I saw that there had been 2 instances, we sent out another inspector in December, and he observed again they are still providing people without license to perform hair braiding services. Given that, we are recommending that this board authorize shop license revocation. They're probably not going to accept, given they haven't accepted the prior settlement offers, but this is a repeat.
So, I mean, I get that they haven't necessarily agreed with us or accepted any of it. So then what are next steps?
Next steps would be to present the opportunity for them to accept the settlement for voluntary shop license revocation, and if they file former charges, that is what the department is seeking, is basically their property right and their license. We'd put on proof that the pictures the inspectors provided, that from all these inspections, that we're practicing in the shop without a license.
Do we feel pretty strong about the case with the photographs we do have?
Yes.
So no,
and the inspector recorded if the people would provide identifying information, and it seemed, if I'm remembering correctly, some of the time the people just wouldn't even give an identification. They wouldn't even provide their names. Operative.
Okay, that's exciting.
Gotta ask, suppose we suppose we close it. How do we get our money? Are we looking at making them pay?
Well, these cases where there's been a civil penalty authorized are in litigation status, and so for those who'd file formal charges seeking the civil penalty, but in a case it'll go to collections, but these cases are hard to actually.
What, you think you're going to get the money, Bobby?
I believe we will.
You do?
I'm familiar with this particular case. We talked about it extensively a while back when it first came up. I still don't believe we're going to get the money. I don't know why we having this discussion really on the case. I believe we're going to end up when it's on the final analysis of closing.
If license revocation is sought, and that's a stiff penalty, and that certainly sends a strong message to other people who might think they can get away. I think that's to the board's discretion if they.
So
if
the
you
question
want
would
to
be,
drop
why
the
are we
penalty.
asking them to voluntarily
Right,
give up
that's my question.
Why are we not just moving forward with revoking their shop license at this point.
That's exactly my question.
For settlement purposes, that's how I've understood just the steps in the game, knowing that, okay, they're probably not going to accept it, but it authorizes it. We may just be authorized for formal charges and bypass that step.
But as a board, Bobby.
Yeah,
can't
perhaps
just
Allison,
slam it
there's
in, right?
precedent, because I know that this is not the first of the sort of 3 strikes to move to revoke the license, but this is the first time I think we've used the word voluntary, which sounds really nice. But I agree with, I agree with Bobby. The only probably way around this, and is just to shut them down.
So is this a recommendation from this committee to the board this afternoon?
This
Is that the process that it would have to follow?
That's what legal's recommending, is just taking that step because the board permits that step for other similarly situated individuals. We usually charges. It's usually, okay, let's try to settle this here, but the question of these civil penalties can be up for debate as well. The revocation itself is the penalty you want, but you're putting this person out of business.
Well, they're putting themselves out, right?
They asked for it.
Bobby, what do you think?
I'm not really for putting people out of business, but I would just like to know up front, yes, are you going to pay us, or what we going to do here? How do we make this thing go away?
If they haven't paid for 2 years now on their first one, and now it's like I guess they think if they ignore us, we're going to go away. And
Got to ask, did we try to work out a payment plan with them? Didn't we try to do that?
yes, we tried to settle on the 2015 and again on the 2016 matter, and our correspondences are received.
But even at this point, Bobby, even if we would have been paid in full, it's the 3rd time, and we've had plenty of shops on our docket who continue to have unlicensed behavior, and regardless of how much they've paid, by the 3rd time they are blatantly having unlicensed folks in their shop, we've asked for revocation.
Okay.
I'm not a favor of it either, but I think it's disrespectful to the board and to the other licensees that there's a shop that just continues to not abide by the law.
I agree.
So do I. So do we need board approval?
Yes.
Okay, so we'll bring that to them then in the meeting?
Yes.
What is a license for natural hair braiding? 200 hours? Is it 200 hours or 300 hours? Yvette when I need her.
300 hours.
300 hours. So they could have all been licensed by now. Yeah.
Yeah, that's just more of that's how we're going to do business, whether you want to let us do business that way or not.
That I don't want to pay taxes, but they're due on the 15th.
I have a question on 25, if we could jump up to 25.
All right.
I guess we have to either make a decision, or it appears that that's still vacant.
The recommendation was provided. I think there's decision blank. We just take note of what the decision was. Fill it in later, but
This issue is coming up more and more about ingredients and not being labeled, and it seems like we're dealing with that more and more, or I'm certainly hearing about it more and more in the field. What is our exact position on that? I see what we're recommending here, But a lot of times when you you got to buy in bulk to get better deals, and you're downsizing it into something that's more usable. How do we handle that? And I ask so we can be proactive about recommending it, as opposed to just trying to maybe dealing with it once we catch them doing it. Because I know for me, if I buy something in a 55-gallon vat, it's going to be tremendously cheaper than if I buy an 8-ounce jar, right? So.
Anita could answer that, but I'm pretty sure in the nail world, just because there are a few of those banned, it might just be the one banned substance, that I believe they have to have everything labeled, no matter what size of the jar.
All right. Yeah, that's why
No,
I'm
I
asking,
mean,
just so I could.
Does what labeled match what's in the jar is step 2, right? But I believe that when they're using those chemicals, it needs to be labeled.
MMA is the issue, right?
Mm-hmm. That might be one to bring up to Anita to verify.
I just want, because I don't know it, to be able to enforce it or discuss it. I feel like I'm in a weird spot by not being able to know. All right.
Our understanding that they do have to have that labeled.
The rules penalize them if it's not, and so I think just for the customer's point, bottle and it doesn't have any sort of label on it, even if it has been downsized from your gallon jug, to say, okay, this is my gel, this is what is getting on my fingers right now.
Because even some of the dispensers are, I know that with the acetone they use to remove nail polish, most of the dispensers for that come out of gallons into like this pump machine that comes up, but there's not ingredients on that. So are we asking to then get labels made with the ingredients if we're downsizing?
I don't think it has to be the ingredients. I think it just has to be the label of what it is. And it might be, Anita can speak to it, but it might just be those few.
Oh, so if it's acetone, it just has to say acetone, not the ingredients.
Right.
Gotcha. Understanding that. Thanks. That's clear.
Well, and I'm certainly no nail expert.
No,
I'm not.
no, but I mean, you can at least identify what it is.
Yeah, I think the biggest, at least when I've met with inspectors, the biggest thing has been with these acrylic nails, this banned substance. I don't know if it works better or if it's cheaper, but there is an incentive for salons to continue to use it and not label it or mislabel it. And that's where the problem is.
And I would add, I think inspectors do need to be able to check for banned substances. So to the extent that they have put their own label on a downsized product, they do need to have the original packaging somewhere in the building as far as best practices. That's not, written in the rules, but, we have to be able to verify that banned substances aren't being used. So if a shop doesn't have anything to show it's in any of the products, that could be problematic if there's an accusation that they are using something that's banned. But again, that's not something that's written in the rule, that you have to keep, all ingredients, evidence of all ingredients in your shop. But in order to enforce the law, that's something that we have to check into when we're doing inspections.
I had a question on 27, if everybody's ready. Right here, Bobby. You go first. Bobby said that five grand.
Are we all on 27? Are we together on this? $11,000 per violation.
Based on the citation schedule, since this is a repeat offense of unsanitary, it's my understanding that it knocks up the civil penalty to $1,000 per violation when it's been a repeat offense. Just paid $3,000 civil penalty in 2015.
Never mind.
Now, we're basically back to square one on this deal as we were on the other one. how are we gonna collect $5,000 from?
Well, they paid 3,000, but they're. I just looked at the pictures and it's very unsanitary.
Some of them see it as, I'd rather pay the penalty than have to enforce it sometimes. I mean, you go to some of these places, they're slammed, they're packed, and it's the cost of doing business. I think when it was 100 and 200, that was the thought.
Oh.
I mean, you start cranking up $5,000, that's a lot of nails.
Yeah, I mean, given the context of where they've been, I don't. Now I feel differently.
A lot
So
of dirty towels, too.
you can get a pretty
Paper
nice cleaning
towels.
service for that amount of money.
The whole thing is when it's second and third offenses, it's basically, this is how we do business. And that's what, I mean, the first time, we've let a million people, just sort of tap them on the wrist the first time around because we all make mistakes, and sometimes it's so unintentional. But by the time it's number 3, I mean, if you haven't figured it out by then, there's going to be 4, 5, and 6 if we don't do what we're doing.
They paid 2,000 of it, or 3,000.
They paid $3,000 consent order for a 2015 inspection that involved unsanitary.
This is a fresh debt right here. Is that right?
Yeah, this is new.
Oh, no, not towards this 5,000. The 3,000 was another inspection.
That's what I'm asking.
Okay.
I think after writing a $3,000 check, you might change something, but yowza.
Okay, so we're going with the recommendation, yeah?
That's all I have.
Have anything else, Aim? Yeah, I didn't either. Everything else seems pretty status quo.
I appreciated the detail in the schools getting a chance to provide detail about complaints that they were receiving. That's helpful.
Thank you. Well, if there's nothing further, this concludes our complaint committee meeting, and we will reconvene in just a few minutes for our full board meeting. Thank you.
Thank you all.